Jwanczuk and the Secretary of State for Work and Pensions, Partner.
Good morning. My client, Mr. Jwanczuk, is not present in court today, and he's asked me to convey his apologies to the court. Unfortunately, he's struggling with the pressures of this case and he's not well.
Yes, no, I can fully understand that. I must apologise, I hadn't realised quickly enough that this is a case where the J is pronounced as an I. It's Jwanczuk.
Yes, Jwanczuk.
Yeah.
That's right. There are a few documents that I need to hand forward. First of all, the Social Security Credits Regulations of 1975 in their entirety, and I would invite you to slot those into your authorities bundle at tab 8. These are the provisions that we discussed yesterday.
Yes, thank
you. About what categories of people may be eligible for national insurance credits. I don't invite you to look through it now. I discussed it yesterday, but as you will see when you look through them, it includes a large number of categories of people who we say are in relevantly different situations to our client, because they include people who were able to work but chose not to do so, because, for example, they chose to stay at home and raise children. The next document is Section 6 of the Human Rights Act. That was referred to yesterday, and it was noted we didn't have that in the bundle. I'd invite you to slot that into Authorities Bundle tab 3. And I've also handed forward a copy of the Housing Benefit Regulations of 2006, which I'll come to later in my submissions, and the case of TP, which I'll also come to later.
Well, we'll leave that out for the moment. The housing benefit rate. Why the housing benefit regulation?
It's relevant to a point that I wish to make about status.
Oh, I see. You haven't made it yet.
No, I haven't made it yet.
No, fine.
And of course, copies have been provided to my learned friend.
Thanks very much.
My Lord, I don't intend to make any further introductory remarks. I'm going to turn straight to the grounds of appeal.
Yes.
In the order in which they appear in the skeleton arguments.
Yes.
So the first ground of appeal is the O'Donnell ground. And Mr. Jwanczuk's position on O'Donnell is as follows. First of all, contrary to the Secretary of State's assertion that Mr. Justice Kerr erred by treating himself as effectively bound by O'Donnell, in fact, the judge's position was slightly more nuanced than that. It may assist just to quickly turn up the High Court judgment.
Yes, I mean, of course. In a sense, all this is water under the bridge, isn't it?
Yes.
The question of what our approach should be. It doesn't really matter whether it's what the judge's was. I'm not stopping you, but I think that's where your focus
I'm going to take that point very quickly.
Okay.
So at paragraph 47, he sets out his approach in principle to O'Donnell. He says O'Donnell is not formally binding. It's a decision on the content of human rights rather than on a point of statutory interpretation. Human rights should, if possible, have the same content, and he wouldn't, if it wasn't distinguishable, he wouldn't depart from it unless persuaded that it's clearly wrong. But as we see from paragraph 75 onwards, he actually accepts the Secretary of State's submission that the High Court has to consider the arguments afresh, and that even if the case is on all fours with O'Donnell, which of course he found it was, he says it wouldn't be right to decide the case only on the basis of O'Donnell. And then he proceeds to analyse all of the Article 14 issues afresh.
Yes, though when it comes to this positive reasoning, he largely does say, I think O'Donnell was right. So
yes,
yeah.
So that's Mr. Justice Kerr's position. Our second point is we agree with the judge's analysis of all of the issues on the merits, and we say he came to the correct decision on the merits. However, we consider that he could and should have gone further and found that O'Donnell was effectively binding on him, and we say that O'Donnell is effectively binding on this court for the reasons that were identified in Dean. In short, when adjudicating on social security legislation that is made on the basis of the parity principle, as the BSP legislation is in this case, a court of equal or lower status in England and Wales should, in consequence of that principle, follow the Northern Irish Court of Appeal, which means in this case following O'Donnell. Now, the Secretary of State's response to that yesterday was that although Dean and Abbott and Philbin were correctly decided, this court should depart from that reasoning on the basis that in this case we are concerned with different pieces of legislation, in that the BSP legislative provisions are contained in primary legislation in Great Britain and devolved legislation in Northern Ireland. And Mr. Sheldon also argued that greater deference should be shown to primary legislation when one is dealing with a convention challenge. My lord, my ladies, I say that that is a distinction without a difference, and that it provides no reason to treat these cases differently when considering deference to judgments of the Northern Irish Court of Appeal in social security cases. Now, I accept, of course, that the distinction between primary and secondary legislation makes a difference to remedy because of sections 3, 4 and 21 of the Human Rights Act. And as my Lord Justice Underhill put it yesterday, hierarchy is relevant to relief, not to whether this court should respect and follow O'Donnell. I also submit that the fact that this case involves a convention challenge also makes no difference. That is a factor relevant only to the intensity of a court's review when considering proportionality and justification. And of course, as we know in this case, the maximally deferential test of manifestly without reasonable foundation was applied in both O'Connell and in this case. My Lord, I go further. Both the Northern Irish and Great British BSP provisions were made by democratically elected bodies, both of which were the primary law-making bodies in the field of social security, and both were made after a process of open public debate. And therefore, the technical fact that one is primary legislation and one is secondary is not...
it's not really secondary legislation, is it?
No, it's not really. It's
not in the sense in which that's normally used.
No,
it's legislation made by effectively a devolved...
Indeed. It's subordinate
devolved
legislation in the sense that it's not made by the Westminster Act of Parliament, but in every other respect, it's similar.
Yes, it may not matter. I just want to make sure when we write our judgments we get the language right. I'm not even sure it's subordinate legislation.
It's just not on the list in the Human Rights Act.
Exactly.
Yes.
It's not defined as primary legislation.
It's a devolved, exactly. We have in England and Scotland, not of course at the time of Abbott and Philby in Scotland, but we have devolved legislatures.
Yes.
And when, except in the very broad sense that their powers derive from, in the one case, the Scotland Act and the other from whatever the Northern Ireland Act, they're basically primary legislation.
Yes, they are.
But I appreciate not in the sense in which that term is used for the particular purposes of the Human Rights Act.
Correct. And I agree with your Lordship that subordinate or secondary legislation is not really an apt description of the Northern Irish Pensions Act.
I'm assuming if you look at the Northern Ireland Pensions Act, you don't find at the beginning a thing identifying this is made under section whatever it is of the such and such act.
Exactly,
Yeah.
that's correct.
Yeah.
That's correct. So even though for the purposes of the Human Rights Act it's defined as subordinate or secondary legislation, in truth it's legislation made by a devolved assembly which has the same accountability and transparency in its decision-making process as the Westminster Parliament. Both bodies are democratically elected, both went through an open process of debate, and both are primary lawmaking bodies for social security legislation. But, my Lord, the case law also suggests that this distinction makes no difference when considering the parity principle or the issue of comity with which you are concerned. We can see from Dean, if we go back to Dean, at Authorities Bundle, Volume 1, tab 26, that Dean was concerned with a piece of legislation that was social security legislation in both Great Britain and Northern Ireland. And if we turn to paragraph 26, the crucial paragraph, we can assume, I don't think it's expressly stated in here, that like any other piece of social security legislation in Northern Ireland, it would have been contained in a separate physical piece of legislation. But what the court says at 26 is that we're not obliged to follow, must accord them the greatest respect, where the decision relates to a statutory requirement which applies or which is the same as that which applies in England and Wales, then we ought to follow that court in order to prevent the undesirable situation of different, identically worded legislation being applied in inconsistent ways. So it doesn't matter to the Court of Appeal that those statutory requirements are contained in different pieces of legislation. What matters is that they're identically worded. And can I also, while we're here, draw the court's attention to that second sentence in paragraph 26, where the decision relates to a statutory requirement. The court does not say here that its reasoning is limited to a point of common law statutory interpretation. All it has to do is to relate to a statutory requirement. And so I submit that that's wide enough to include an analysis of whether a statutory requirement breaches a person's human rights, contrary to the Human Rights Act. In other words, it's wide enough to include a convention challenge.
But also presumably wide enough to include a conclusion of the Court of Appeal of Northern Ireland that a Section 3 reading of the relevant provision is possible, and what that Section 3 reading is.
Yes. Now, at paragraph 27, one will see that the Court of Appeal refers to a case of RSB 190. And I'm going to take your lordship and ladyships to that case, which is in the bundle at tab 14.
I don't mind you doing so at all, but there is the passage quoted from Abbott and Philbin includes this, to me, slightly puzzling or provocative exception for where there are compelling reasons to the contrary.
Yes.
The moment I don't see what sort of things those could be, and I don't know whether you are going to make any submissions about that. Maybe it's just a safety valve put in without any great thought by whatever said.
Well, what we know in the case of Dean is that having set out paragraph 26, it then went on not to follow the Northern Irish Court of Appeal decision with which it was concerned, both because the point had been conceded in that case and not properly argued, and also because it was obiter and not part of the ratio. So
yes, but in a sense, that's not really quite the point. That's a very particular case where if this had been a domestic statute,
yes.
Sorry, domestic decision, start again, an English decision, you would have been entitled not to follow a court of coordinate jurisdiction. I think the phrase in Abbott and Philbin assumes that the decision in question is binding.
Yes.
And yet still suggests there could be compelling reasons to the contrary. And I don't think, as I recall, Dean, that Lord Justice Ward, as it were, justified his departure by saying this is a compelling reason to the contrary case. He just said, implicitly at any rate, well, we're not bound by it anyway. It's not binding authority. So I think what happened in Dean doesn't really cast any light on compelling reasons to the contrary.
No, it doesn't.
And I don't think we'll need in our judgment to say what we think about it, but if you had any submissions, I'd be interested to know what they were.
It is possible that compelling reasons means that the decision is per incuriam. That might be an example of a compelling
Well, that's
reason.
really like another one like Dean.
Yes. But it is difficult to think of what other compelling reasons there could be. Clearly, it can't amount to the court saying to itself, I would have reached a different decision, and I'm going to substitute my own decision for that of the Northern Irish Court of Appeal. So I'm not sure I can take it much further other than to say
I'm not surprised. I just
a
thought I'd give you the
safety valve.
opportunity. Yeah. Thank you.
The reason I want to take the court to tab 14, which is I accept a decision of a tribunal of commissioners rather than the Court of Appeal, is that it deals with this point about Northern Irish social security legislation being contained in a separate piece of legislation. And it addresses that in very forthright terms. So it's tab 14. And can I invite the court to read the head note at paragraphs 2 and 3?
Just for my note, which commissioner is it?
It's the Tribunal of Commissioners. It's a panel decision of 1990.
Sorry, is this cross-referred to in Dean?
Yes, it
you
is.
Took us to...
I did. It's paragraph 27 in Dean.
Thank you.
And indeed, I see what the chief commissioner, if I'm remembering my childhood well enough, Leonard Bromley, I think, was a distinguished Chancery Silk.
Ah, I'm grateful for
Well,
that
I think so.
information.
Either
head
the
note-
juniors wants to do some Googling. It would be interesting to know that I remembered that right. But he was a figure I think people were talking about when I was a young chap. Right.
So paragraphs 2 and 3 of the head note, could I invite the court to read those two paragraphs?
Yep.
And then could I invite the court please to turn to page 121. It's paragraphs 11 to 15, which I would invite the court to read at its leisure. But for these purposes today, I'm short of time. In paragraph 11, the last sentence says, does the decision of the Court of Appeal in Ireland operate to bind the commissioners in England and Scotland? And at paragraph 12, it makes the point that the commissioners in Great Britain exercise their function under legislation which applies to England, Wales and Scotland. That answers your lordship's question of yesterday, but not to Northern Ireland. They then go on at page 122 to describe the position vis-a-vis Scotland. And then at 13, I don't need your, the court to read 12 for the moment. But at 13, it says this: however, the position is different in respect of the superior courts of Northern Ireland.
If this is a long passage, why don't we just read it to ourselves?
Of course.
The whole para?
I don't actually need your the court to read paragraph 12 because it
No, but the
deals-
whole, we're talking about 13. How much of 13 do you want us to read?
all of 13 as far as the quote.
Okay.
Thank you.
Yeah.
And 14 refers to Abbott and Philbin.
Yeah.
Then 15, can I invite the court to read the entirety of 15?
Yeah.
And just to clarify, the section 142 of the 1975 Act that's quoted is now, as you've seen yesterday, set out in section 87 of the Northern Irish Act. I adopt that reasoning in its entirety, and what it is clear is that the tribunal were perfectly aware that social security provisions are contained in separate pieces of legislation as between Great Britain and Northern Ireland, but it mattered not.
Okay, got the point.
And that's particularly the case where the Northern Irish Court of Appeal decision is unanimous, as is the case here.
That can't logically make a difference, though, can it?
No. But I'll take the point where I can, my lord.
Okay.
My lord, that deals with my submissions on ground 1,
Okay.
O'Donnell. Turning now to ground 2, status. The Secretary of State contends that the High Court erred in concluding that the claimed status was a valid other status. I will address both the claimed status that was found to be valid by the Northern Irish Court of Appeal in O'Donnell and the High Court below, and then the posited refinement put forward by Lord Justice Underhill yesterday.
Yes, don't feel obliged. I mean, do look that gift horse in the mouth if you think it's there's something wrong with its teeth.
I'm grateful, my lord. First
Just because
point.
the court suggests something isn't always right.
Indeed, and I'll come to that. The first point is it's important to be clear about what was the claimed status that was found to be valid. There was some discussion yesterday about differing formulations of the claimed status. It was pointed out that the High Court judgment didn't mention lifelong inability to work, whereas the order did. So just to clarify, the status claimed in both O'Donnell and in the court below was the same, namely that the applicants for BSP in each case were, and I quote, the spouse of a deceased who was severely disabled so that she was unable to work and therefore...
Hang on 1 second. Yeah.
and therefore unable to satisfy the contribution condition. Now, both courts, Northern Ireland and below, found that that was a valid status. And in fact, Mr. Justice Carr's order is in identical terms to the order made by the Northern Irish Court of Appeal in O'Donnell. And the reference for that, I don't need to take you to it, is paragraphs 102 and 103 of O'Donnell. Now, I submit that that is also a distinction without a difference, because it's implicit in the formulation of the claimed status that the deceased spouse has to have been so severely disabled that he or she was unable to work throughout their working life, and by reason of that, or therefore, was unable to satisfy the contribution condition.
Just give me the introductory words of the pleaded formulations. Deceased, was serious?
The spouse of a deceased,
yeah,
who was severely disabled so that
okay, got it. That's all I wanted.
she was unable to work, and therefore.
Okay.
That's the first point. The second point, what precisely is the Secretary of State's objection? It now is clear that the Secretary of State doesn't appear to have any objection to the phrase disabled or severely disabled. And nor could she, because it's common ground and well established that disability is a valid status. For that proposition, see the cases cited in O'Donnell at paragraph 57 of the judgment. For your record, it's page 1502 of the authorities bundle. It also appears to be common ground.
Sorry, just well established that.
It's well established that disability is a valid status.
And what were the authorities you were saying?
The cases are cited in O'Donnell on that point at paragraph 57. I don't need to take
No,
you
that's
to it.
fine.
It's page 1502.
Yeah, thank you.
It also appears to be common ground that the status need not be the status of the complainant themselves, because indirect associative discrimination is sufficient. And for that, see O'Donnell at paragraph 56. Now, there was much discussion yesterday about disability plus and whether that could amount to a valid other status. And as to that, I submit that it's clear from the case law that disability with an additional element or qualifier, I'm not going to call it disability plus because I agree with the court's view that that's a rather inelegant and imprecise term. But disability with an additional element or a qualifier can amount to a valid status. I'm going to take these authorities, I hope, at a quick hop, but it's important that the court sees them. First of all, I want to start with Matheson, which was a 2015 decision of the Supreme Court. It's in the first volume, last tab, it's tab 30. It starts at page 850 if you need the page reference. It's tab 30. This was the disability living allowance.
Sorry, I've got the same problem, my collapsing bundle.
I'm so sorry, I ought to have water.
No, don't worry, no, I ought to have arranged for my clerk to find a new one. Well, I ought to be like the master of the rolls and do everything on screen. Okay, I have it now.
I'm grateful. This was a disability living allowance case where a child's allowance was cut off because he'd spent so long in hospital. The relevant paragraphs are 19 to 23. Could I invite the court to turn those up? They start at page 859. Paragraphs 19 to 23. And at paragraph 19H, the bottom of that page, we see the case that was put, that the child's status was that of a severely disabled child, it's letter H, who was in need of lengthy inpatient hospital treatment. That was the claim status. And in paragraph 20, letter B, the Secretary of State disputed that that was a valid status. It's the last sentence in paragraph 20. At paragraph 21, there was a review of recent case law, and at paragraph 21, letter E, in reference to the case of RJM, it said the House held, the House held that a valid status included not only the suspect grounds, or to use a less ambiguous word, the core grounds, which according to Lord Walker of Gestingthorpe at paragraph 5, included gender, sexual orientation, pigmentation of skin, and congenital disability. So I'm just going to make the point while we're there that having a congenital disability is now regarded as a suspect ground. That's relevant when I come back to justification. And then over the page at paragraph 23, the Supreme Court concludes confidently that as a severely disabled child in need of lengthy inpatient hospital treatment, Cameron had a status falling within the grounds of discrimination prohibited by Article 14. And can I invite the court to read the rest of that reasoning? So there's no doubt in that case that if I use the phrase disability plus, an additional element beyond just disability by itself was a valid status. The next case I invite the court to turn up is in the next authorities bundle, volume 2. It's the case of Stevenson which was a Court of Appeal case of 2017. I'm taking them in chronological order. Tab 36. See the court there, Lady Justice Arden, Lord Justice Jackson and Lord Justice Henderson. Now this case concerned whether a claimant who was disabled was unlawfully discriminated against by virtue of the fact that a benefit called support for mortgage interest, or SMI, which was received as a component of the income support, was capped at a certain level, in effect because of her disability. Now, paragraphs 36 to 41 are the relevant paragraphs. They start at page 1004. Those paragraphs contain a helpful summary of the law, but I invite the court's attention in particular to paragraph 41. Could I invite the court please to read that paragraph, 41, especially the last sentence.
Yep.
Now, the claimed status in that case was a disabled person who first claimed income support before the 5th of January 2009 and was thereby prevented from taking advantage of a cap. One cannot think of perhaps more of a plus for disability plus than this. But at paragraph 50, the Court of Appeal accepted that that was a valid status. Can I invite the court to read paragraph 50?
Yeah.
I'm grateful. The next authority that I invite you to look at is the case of SH and Norfolk. It's just a few tabs on in tab 46. This was a decision of Mr. Justice Griffiths, and it concerned a change in
Mr. Justice Griffiths. I thought you said Lord Justice Griffiths.
No, Mr. Justice Griffiths.
Yeah, sorry, I misheard.
It concerned a change in the local authority's charging policy for care and support services, which in effect resulted in increased charges for the claimants who were disabled. Now, paragraph 52 sets out what the...
Sorry, 32.
no, 52, my lady. Well, we see, first of all, I apologise, in 51, that the status relied upon is that she's severely disabled. And then at 52, it's maintained that being severely disabled is a status within the meaning of Article 14. And then the relevant paragraphs are paragraphs 58 to 63. And there, the court finds that being severely disabled seems to me to be exactly the sort of personal characteristic which has always been recognised as protected. And then in 59 there's a review of the case law, to which I've taken the court already, Matheson and indeed O'Donnell. And then at 60, the council accepts that not only disability but degrees of disability can be in other status. However, it objects that the claimant's proposed status of severely disabled is not precise enough for Article 14 protection. We see what the judge says in 61 about it has to be ascertainable, but then the key paragraph is 62, and can I invite the court to read 62? and the conclusion in 63.
Yep.
Now, I submit that paragraph 62 and 63 are significant because in that case, the court considered that receipt of incapacity-type benefits were capable of acting as a proxy
Yeah.
to determine whether or not the claimant was severely disabled.
So that's relevant to the submissions you're going to be making about my
Indeed.
way of putting it.
And the final case is actually a case that has been relied on by my learned friend. It's the case of MOC at tab 49. That's a decision of the Court of Appeal of 2022, very recent. And as the court knows, this was another case concerning disability living allowance, which was cut off for the same reason, because the disabled claimant had spent a lengthy period in hospital. Looking at the head note at letter F, we see there that in this case the Secretary of State conceded that the claimant could rely on the status of being a severely disabled adult in need of lengthy inpatient hospital treatment. The only aspect that they disputed was the claimant's assertion that the relevant status should also encompass lack of capacity.
And presumably the concession was based on Matheson.
Presumably.
Yeah.
And of course it was only the latter, the question of lack of capacity, that the case was concerned with. There was no difficulty with the concession that the former status, disability plus, being severely disabled and in need of lengthy inpatient hospital treatment, was valid. So, my lord, my ladies, I submit that the cases demonstrate that disability plus, or disability with an additional element or a qualifier, can amount to a valid status. I contend that the additional or consequential element of the claim status in this case also amounts to a valid status. And I adopt my Lady Justice Falk's suggestion made yesterday that the claim status amounts to a subset of disability. That must be right, because we're only seeking protection, or an exception in this case, for a subset of all disabled people. We're not contending that all disabled people should be entitled to this exception. Only those who were so disabled that they were unable to work through their entire working life. So, it appears that the Secretary of State's only objection to the claim status is in relation to the phrase unable to work. And the Secretary of State contends that this phrase is not sufficiently certain or ascertainable. Now, as to that, it appears from my learned friend's submissions yesterday that he relies on 3 separate arguments for that proposition. First, he relies on the case of MOC, which we've just looked at, for the proposition that for a status to be valid, it must be reasonably certain. And you'll recall being taken to paragraph 65 yesterday, where Lord Justice Singh found that the question of whether someone has capacity or lacks it is not a status as such. His Lordship says there needs to be a reasonable degree of certainty, and that a person's capacity may change from time to time and do so quickly, and that is not a sound foundation for the status required by Article 14. I don't take issue with any of that reasoning. It's clearly correct on the facts. But what I submit is that MOC is clearly distinguishable from the current case. Because if you are assessing a living person's decision-making capacity, it's obvious that it may change from time to time. And therefore it doesn't provide a sound foundation for an Article 14 status.
There's a further point though too, isn't there, that capacity isn't a global concept. You've got capacity for different types of decision.
Indeed. But here, the relevant question in the BSP context is whether the applicant's deceased spouse was, not is, but was unable to work throughout their working life due to disability. And that has to involve an assessment of past events.
But it's also binary at any particular time. You either could or you
Indeed.
couldn't. Whereas, as has just been said, capacity is multifaceted.
Indeed, it is binary, so that if the Secretary of State finds in any particular case that there was a period of time where a claimant was able to work, then they wouldn't fall within the accepted class. We're not seeking protection for that class of person. We're only seeking protection for those people who were unable to work throughout their working life because of disability. So the status that we are claiming is valid is not capable of changing in future, because you're looking backwards over the course of a deceased person's life. And if, as I've said, the person was, for certain periods of time during the past, able to work, then they don't fall within the affected class, and they're not entitled to BSP on our case. That deals with the Secretary of State's first argument. The Secretary of State's second argument is that he relies on the case of Clift against the UK, which is at tab 54 of our bundle.
But that's an isolated dictum, and the outcome was that the status was recognised by the Strasbourg.
Indeed, indeed. That is an isolated dictum. What the dictum is set out at page 1612 at paragraph 55. And it says Article 14 doesn't prohibit all differences in treatment, but only those differences based on an identifiable, objective or personal characteristic or status by which persons or groups or persons are distinguishable from one another. And my learned friend said yesterday that test is not satisfied in this case. But of course, that's only a partial and incomplete summary of what the European Court of Human Rights held in this case. What they went on to say in paragraph 55 is that the list set out in Article 14 is illustrative and not exhaustive. At paragraph 56, that the words other status have generally been given a wide meaning. And paragraph 59, that the protection conferred by Article 14 is not limited to different treatment based on characteristics which are personal in the sense that they are innate or inherent. So that really gives a full flavour of what the court was saying in that case. But in any event, even if you were to find that that short dictum on which my learned friend relied is the applicable test, we say it's met in this case. Because it's already established that being disabled or severely disabled is a personal characteristic and a valid status. And secondly, being a person who is so disabled that they're unable to work throughout their working lifetime must also be a socially, economically, and psychologically significant personal characteristic. It is not something that someone chooses. Being so unable to work because you're so severely disabled is a status forced upon them by reason of their disability. And it also exposes them to social exclusion. In my submission, it's hard to imagine a more personal characteristic than being so severely disabled that you are unable to work. It's clearly also identifiable. It's possible to distinguish between different groups of person. As Mr. Justice Kerr held below, the reason for not being able to satisfy the contribution condition is inability to work due to disability. If disability is not the reason, for the inability to work, then you fall outside the class. If it is the reason for the inability to work, then you fall within the class. So it's perfectly identifiable. It's also objectively ascertainable. In my submission, it is perfectly possible for a decision maker within the Department for Work and Pensions to make an objective assessment based on the individual facts of a case as to whether, on a balance of probabilities, someone is unable to work, and if so, whether the reason for that is disability. So that deals with the Clift point. The third argument that the Secretary of State makes is a factual argument which overlaps with its justification arguments. Secretary of State's position is that the claimed status...
Sorry, you'll probably need to come back to this. When you say it is obviously objectively ascertainable by a caseworker on the facts of an individual case, whether someone is unable to work by reason of the severity of their disability, what sort of process are you envisaging that happening by?
A process similar to the process set out in the Northern Irish guidance. Which apparently has been working without any difficulty.
Well, but the Northern Irish guidance acknowledges that actually, if you follow it, you will sometimes give the benefit to people who are not entitled to it. It's a rough and ready, non-objective.
I don't accept that that's what the Northern Irish guidance says. That's what my learned friend says. And I'm going to come back to that. But I say it sets out a useful framework. You start with, were they in receipt of certain incapacity type benefits? You can cross-check by then looking at, were they in receipt of any benefits that were inconsistent with inability to work? For example, were they in receipt of job seekers allowance? And then if you need to do so, you can ask the claimant for evidence. And the burden's on the claimant to show on a balance of probabilities that they're entitled to BSP. If they can't meet that threshold, then it's open to the Secretary of State to decline the claim. And I say that's a perfectly reasonable and workable way of dealing with the matter. But I'm now coming to the point which I think is concerning your Lordship, and that's the third argument that the Secretary of State relies on, which is, as I said, the factual argument. Because the Secretary of State's position, and this is relevant both to status and justification, is that the claimed status of being unable to work due to disability is too imprecise or uncertain because, Mr. Sheldon says, to assess whether a person falls into the O'Donnell class of being so disabled that they're unable to work, that would require the Secretary of State to determine that it's impossible for that person to work, and that would be administratively unworkable because there's no valid or simple proxy which illustrates that it's impossible to work. Now, on this point of equating inability to work with impossibility, it is quite clear that that's the Secretary of State's position because it's set out in their skeleton argument, paragraph 46.
Hang on.
I don't need to take you to these documents, but I'm going to
No,
give
just
you
give me the
references.
reference. Skell 46.
Skeleton, paragraph 46, and Helen Walker's witness statement, paragraph 63. And that's supplementary bundle, tab 6, page 57. Now, as to that, we say that that impossibility test is a straw man argument. Impossibility has never been used as a test of anything in social security law, and nor has it been used in this specific context of measuring the limitations or benefit entitlements of a disabled person.
I didn't think that was his point. I thought his point was that inability is necessarily an imprecise concept. How unable must you be? There will perhaps be extreme cases, somebody who's in a coma, and slightly less extreme cases, but there will be other cases where you have great difficulty in working, but it's a question of degree and assessment, whether that can properly be described as inability to work.
Well, the Secretary of State...
Are you perhaps using concepts like shouldn't reasonably be required to work, which we've seen in one of the statutory provisions?
Yes. Well,
that must be right, mustn't it? That,
yes.
It is an imprecise concept, requires a judgment, ultimately, of, I suspect, of reasonableness.
Yes.
We haven't been shown all the statutory language for all these benefits, but the concept of reasonably required to work looked pretty good to me.
Yes, indeed, but in this respect,
conceptually,
the Secretary of State's argument has somewhat morphed. Its original position below, and indeed in its skeleton argument here, is that you have to show that it was impossible to work. Mr. Sheldon's submissions yesterday were slightly more along the lines that your Lordship has just summarised, but there is no doubt that there is no impossibility threshold, and never has been, in social security legislation, and that the test is reasonableness. But as to your point earlier, my Lord, the status of being unable to work, Mr. Sheldon has suggested, is too imprecise and involves a degree of judgment. But in a sense, that's true of all of, or many of the statuses. Obviously not for gender, but it can be true of other statuses such as religion or belief. How does one tell whether someone's a Christian or not? For example, that's going to involve a degree of judgment on the individual facts of the case. So I don't accept that that argument really meets my point.
Hang on 1 second.
And the concept of disability itself is not, you can't sort of hold up a litmus test and go,
No.
You are, you aren't. I mean, depending on the statutory context, say in an employment case, there's a statutory definition in the Equality Act,
Yes.
and the Employment Tribunal has to apply that statutory definition to the facts.
Absolutely. And in this context, the Secretary of State has always assessed disability for the purposes of incapacity type benefits by reference to a reasonableness test. And in fact, we saw that in one of the pieces of legislation yesterday. That was the Welfare Reform Act of 2000 and...
Can I, just before you take us to that, get rid of one niggle in my mind while we're on this? Certainly in Matheson and MOC, the problem is taken away because someone else has made the judgment. The judgment, for example, that someone requires long-term hospital treatment. Well, they were in hospital for more than 14 days, so that was clearly the case. It's not quite the same where the decision maker themselves has to make the judgment.
No, but we say this is more of a McLaughlin or Jackson type case, where in that case, the court said we are now expecting decision makers to make an assessment about whether a couple is cohabiting. And as we know...
That might be a better example than your example of religion and belief.
Yes. So cohabiting, as I submitted yesterday, is a very imprecise term and would require any decision maker to make very intrusive questions.
In other words, it's a question of assessing evidence, making primary facts and drawing inferences.
Absolutely. And the government had no problem with that because it subsequently amended.
Yeah, but
the
it's
ESP
with
provisions.
respect to my it's more than that. It's not just making inferences about facts. It's then deciding whether to apply a label. Supposing cohabiting, you had that they lived in the same house 3 days out of 5.
Yes.
They had intimate relations every now and then. So at the end of the day, you may get the facts perfectly clear, but you've still got to decide whether or not that deserves the label cohabiting.
Yes, but as we know, the Supreme Court had no difficulty.
Yes, quite. I was just trying to identify that it's not just a question of having to make a judgment about facts which were maybe difficult to ascertain. Once you've ascertained all relevant facts, cohabiting is an example of a label
Yes.
which still requires a judgment, an evaluation.
It does, as it does in this case, inability to work.
Yeah.
But that, as a matter of justification, shouldn't, I submit, be fatal. Indeed, it's just one factor to take into account, and as we've seen from the case law, many previous cases have found that is not sufficient to justify excluding an entire class from entitlement to a benefit. See McLaughlin, Jackson, O'Donnell,
Yeah, well,
and below.
we got the point. Yeah.
Yes. Can I take the court very briefly to the relevant provisions? You were taken to one of them yesterday, but just so that your record is complete.
Yes. No, that would be helpful.
Yesterday, we looked at the Welfare Reform Act of 2007. Can I invite you to turn that up? It's Authorities Bundle, tab 5. And this is the provision that relates to Employment and Support Allowance, or ESA. And we can see there that a person is entitled to claim ESA if he satisfies the basic conditions, and the basic conditions are that the claimant has limited capability for work, and one sees at the bottom at paragraph 3F is not entitled to a job seeker's allowance, so that would be a benefit that's inconsistent with having limited capability for work. And over the page, a person has limited capability for work if his capability for work is limited by his condition, and the limitation is such that it's not reasonable to require him to work. And that is determined by an assessment which is done by applying a set of functional descriptors. Can I invite the court to turn to tab 11? These are the Employment and Support Allowance regulations of 2008 that set out how you determine someone has limited capability for work. Section 19, subparagraph 1, it is going to be determined on the basis of an inability or limited capability for work assessment. And then it sets out what that assessment is of. It's of the extent to which a claimant who has some disease or bodily or mental disablement is capable of performing the
So where are
activities.
you reading from?
Section 19.2.
19.2, sorry, yeah. Thank you, yes.
So it's an assessment of the extent to which they're capable of performing the activities prescribed in Schedule 2. And in subsection 3, the claimant has limited capability for work if, by adding the points listed in a particular column of Schedule 2, the claimant obtains a score of at least 15 points. Now, when we turn to that schedule, which is at page 89 onwards, we see there is a total of 17 functional descriptors. They include mobilising unaided, standing and sitting, reaching, picking up and moving or transferring by the use of the upper body, and so on.
Yeah.
They are very low thresholds. And yet of this total list of 17 descriptors, which goes up to page 94, the claimant has to be able to show that they can't do 15 of them out of 17. If they can't establish that, they don't get entitlement to ESA, and they are not regarded as having a limited ability to work. And my submission, that demonstrates how hard it is to qualify for that kind of benefit.
Well, surely that's not the point, is it? Why are we interested in how hard it is? We're just interested in the question of the character of the assessment that needs to be carried out.
It comes to the next point I'm going to make, which is in relation to the argument that you're going to, if you allow people in the O'Donnell class, you're going to allow in people who actually are able to work. But I'll come to that in a moment, because the suggestion is made that it's easy, in a sense, to jig the test or the assessment or to get into this class of people.
Well, I'm not sure that is being suggested, but
well,
anyway, keep going.
The next statute that I invite the court to look at is at tab 6, and that's the Welfare Reform Act of 2012. This relates to universal credit, not ESA. And again, we see in section 37 that there's a reasonableness test for whether someone has limited capability for work. It's sections 1 to 4.
Yeah.
I'm grateful. And therefore, in my submission, generally speaking, receipt of these two kinds of incapacity benefit, that's what we're talking about here, is a particular kind of universal credit.
The phrase which old people like me think of, incapacity benefit, that's a very legacy benefit indeed, is it?
That is a legacy benefit.
But does that go back before? The incapacity benefit has not been awarded since 2005, is that right? Has that been replaced by ESA?
2007. Yes, it's been replaced by the ESA. I can take the court through those legacy benefits, but in short, the predecessor benefit to ESA was incapacity benefit. That was created by the Social Security brackets incapacity for work close brackets Act of 1994, and it's obvious from its title that it assessed incapacity for work.
Did that use a reasonableness test?
Your junior's
Mr.
not-
Royster is saying
Yes, it did. It did.
And did it use a reasonableness test assisted by regs asking those very schematic questions of the kind?
No, it was slightly different. But what it did do is it had regs made under the Act which deemed certain types of disability to count as incapacity for work. And what's relevant to this case is that it automatically treated a person suffering from a severe and progressive neurological or muscle wasting disease as being incapacitated or unable to work. That's Regulation 10, subparagraphs 1 and 2, subparagraph D, Roman numeral 2, and that's found in the authorities bundle at tab 10. That would of course include muscular dystrophy, which my client's wife suffered from. Now the predecessor to that benefit was sickness benefit, and that also assessed a person's incapacity for work by reference to a reasonableness test. And that is set out in the Social Security brackets Contributions and Benefits Act close brackets of 1992, which is in your authorities bundle at tab 2. And all of those predecessor acts going back to 1996.
But that looks to me like a consolidation act. Sickness benefit can't have been in existence only for 2 years.
No, but they all.
The reason I'm asking for all this history is not just to be pedantic, because actually these are the inquiries that we've really basically with in some cases with deaths in 2023, people before pensionable age, we are looking back to the 50s, aren't we? Or no, not the 50s, the
no.
70s. 70s.
Back to the 70s.
And the inquiries which would have to be carried out would have to identify, if you were going to use receipt of these benefits as a proxy,
Yes.
would have to go back to the 70s. And so, and maybe it's in the skeleton somewhere. I haven't reread them overnight.
Miss Walker's witness statement.
Yes.
Has something to say.
Well, I think she identifies the legislation, but she doesn't say what the provisions required.
No, we've dealt with it in our skeleton though.
I don't want you to do again an exercise this in your skeleton. So, but where will we find all this in the skeleton?
In the skeleton, it's paragraphs 49, or it starts at 47 and it works through to 53.
Is that right? I'm looking at the wrong skeleton.
My skeleton, of course, is at tab 3.
We don't have tabs.
Page 52.
Yeah.
Starts really at 46 and it goes through to 53.
Yes, but I don't remember having noticed when I was reading this an analysis of all the benefits back to the earliest possible date, some date in the 70s, and seeing what their requirements were. And that may be my fault. I may not have followed up the footnotes or something.
Well, for example, paragraph 51 goes back to the 1950s.
Yes, but it's not all schematically set out.
No.
And I think, as my lady says, it is to some extent dealt with in Walker, but again, I don't think she actually says what the relevant provisions of each of these acts are. Or if she does, again, I haven't taken it in.
I'm informed by my learner junior that the concept of sickness benefit goes back to the 1946 original act.
That's great. I mean, I think what would help me, and I think we're spending too long on this point.
We are, and I do need to press on.
Yes. What would help me would be simply to have a note of the relevant benefits back to the earliest possible date. Sounds like we might be able to go back to 1946, just saying what the benefits are which involve an assessment of inability to work under whatever phrase is used, and what the tests are with cross-references to the relevant provisions.
Of course.
Don't want the provisions themselves attached, so it can all probably be done on one page or worse two. Okay.
Yes.
Now but I think with respect, this is extremely meticulous and helpful stuff. But and I know in the last 10 minutes we've slowed you down, but you've got to keep your eye on the clock.
Indeed. So I'm going to press on. Having said that receipt of incapacity type benefits will generally speaking act as a sufficient proxy for being unable to work, that then leads to the positive reformulation of the relevant status.
Yes.
And as I understood it, the posited status is that the contribution condition is treated as met if the person was in receipt of these certain specified incapacity type benefits for the whole of their working life. And that would be on the basis that receipt of those benefits is a proxy for inability to work. And your lordship put as an alternative that instead of reformulating the status, one could require the status to be evidenced by receipt of those benefits.
Yes.
Now, in general terms, we would agree that it's open to the Court of Appeal to take either of those routes. But we submit that it isn't necessary to do so because the Department for Work and Pensions is capable of formulating guidance as to the evidence required to determine inability to work, just as they have done in Northern Ireland. Now, the reformulated status would certainly be a valid status And it would cover our case because Mrs. Jwanczuk was in continuous receipt of incapacity type benefits during her working lifetime. But I don't want to look the gift horse in the mouth, but I also want to just raise with the court that the status is likely to be a rather blunt instrument that may have some unintended consequences. Now, as we saw below, Mr. Justice Kerr declined to decide whether receipt of certain benefits was a valid proxy, and I make the point just as an aside that it's not the case, as Mr. Sheldon asserted yesterday, that the judge did not accept that receipt of benefits was a valid proxy. To the contrary, in paragraph 93 of the judgment, he said, no doubt in many cases it will be. And the reason he thought it didn't act as a proxy in every case is the point that my learned friend made yesterday, that the benefits legislation permits people to carry out some limited forms of exempt work and not lose entitlement. And so the Secretary of State's position is that you shouldn't make an exception for people who have received those incapacity benefits throughout their life, because as a result of how the reasonableness to require work test functions, within that group there could be people who were in fact able to work. In other words, there could be cuckoos in the nest who end up qualifying for BSP when they shouldn't have done. And I think that was a point that my Lady Justice Laing made as well yesterday. But as to that, I make the following submissions. We say that this position is founded on a rather distasteful stereotype about benefit claimants, that people are claiming these payments as a lifestyle choice rather than out of necessity. We say there is no evidence to support that notional subgroup as being anything other than negligible in size. Certainly no evidence has been advanced by the Secretary of State to suggest otherwise. And we submit further that in reality, very few people are likely to fall into this category because, as I hope I've demonstrated to the court, the assessment for whether someone can reasonably be required to work and is therefore eligible for incapacity benefits is very rigorous. And it's very difficult to qualify for these kinds of benefit. So we submit that it follows from that it would be disproportionate to exclude an entire category of people like Mr. O'Donnell or Mr. Jwanczuk, whose wives were unable to work due to disability, from entitlement to BSP just because there may be a few people who can work and who get a benefit that they're not entitled to. We also submit, and I'm going to have to take this point very quickly, that the Secretary of State's position is blatantly inconsistent with the approach that he or she has taken in other contexts. Because in the Article 14 discrimination case of MA against Secretary of State for Work and Pensions, which is found in the bundle at tab 33, this was a Supreme Court case of 2016. There, the court was considering the treatment of two groups. First of all, adult partners who cannot share a bedroom because of disability. That's paragraph 41 in the judgment. And the other group was a child who requires overnight care. See paragraph 45. Now, the Secretary of State could have said, by exact analogy with our case, well, how can I ever identify that they require something or cannot do something?
So you're going to take this point quickly. I speak myself, I can't take it all in if you take it quickly.
I'll slow down. Shall I take you to the judgment?
Yes, if you think it's important enough.
Yes, it's tab 33, so it's in the second authorities bundle.
Tab 23.
33.
33.
It's often known as Carmichael, but there were a number of claimants in the case.
Yes.
Supreme Court 2016, and the court was considering a disability discrimination claim under Article 14 concerning treatment of two groups. First of all, paragraph 44. This is the Carmichael group. Mrs. Carmichael cannot share a bedroom with her husband because of her disabilities. And so the status...
So which paragraph are we on?
44 and 45. Page 949.
Good, thank you. Yeah.
So the Carmichael case cannot share a bedroom with her partner because of disability. In 45, the Rutherford type case, a child who requires overnight care. Now, the Secretary of State could have said, by analogy with our case, well, how is a decision maker to determine whether someone requires an overnight carer or cannot share a bedroom because of disability? But in fact, after those cases succeeded in the Supreme Court, what did the Secretary of State do? They passed an amending regulation, Regulation B13 of the Housing Benefit Regulations of 2006.
Are these references in your skeleton?
No, this is what I've handed up this morning.
Okay.
The Housing Benefit Regs of 2006 were amended to include provision for those two groups, and the Secretary of State did this in the definition section, which I've handed up, by defining a member of a couple who cannot share a bedroom and a person who requires overnight care by reference to a test of reasonableness. Now, the the relevant definitions are found at page 10, bottom of the page, member of a couple who cannot
Wait. Page 10.
10.
Yeah, got it.
Bottom, member of a couple who cannot share a bedroom. And they've gone through a meticulous definition exercise ending in B on page 11. The relevant authority is satisfied by virtue of his or her disability is not reasonably able to share a bedroom with the other member of the couple. And that does not appear to have been too difficult for the Secretary of State in that case. And then the other category of case is at page 13, a person who requires overnight care, about halfway down. And over the page, it's again defined by reference to the relevant authority being satisfied that the dwelling contains an additional bedroom and that P did or will reasonably so require. So again, done by reference to a reasonableness test. So my submission...
Sorry, where's that? B?
Yes. Page 14.
The last
Okay.
paragraph.
It's
Yeah.
the last beginning but.
Thank you.
So the point is this. Despite all of the arguments about administrative difficulty, justification and so on, it is in fact perfectly possible for the Department for Work and Pensions to come up with a working definition of what is meant by inability to work by reference to a reasonableness requirement. My Lord, the other possible difficulty with your suggested reformulation of the status is that it may exclude people who would otherwise be entitled by falling into the O'Donnell class of person. For example, 16 to 18-year-olds, or those who'd spent a period of time overseas, or those who never applied for incapacity benefit even though they were eligible for them. So, in summary, in relation to the court's positive reformulation of the status, yes, it would be possible to reformulate the status in the way suggested, and if pushed as an alternative to our primary case, we would accept that reformulation because it would catch our client. And it would mean, of course, that the Secretary of State's arguments about administrative difficulty fall away. But it is somewhat of a blunt instrument and may exclude some people who would otherwise be...
No, thank you. Well, that's very helpful. I see how you put it. Yeah.
And alternatively, it could be, receipt of these benefits could be treated as a matter of evidence, either as a starting point or as the definitive end point. And of course, if it was just a starting point, I accept that's going to increase the administrative burden. But that's a point going to justification, not to whether there's a valid status. And in any event, I would submit it's not sufficient to justify excluding this entire class. And finally, in any event, even
Well,
if...
treating it as evidential merely as a starting point is effectively only what is happening under the Northern Irish system anyway.
Exactly.
So I think really what I had in mind was treating it as conclusive evidence,
Yes.
which I think, as I said at the time, would ultimately come back to much the same as making it part of the status.
Yes, much.
And you're
the same.
against that for the same reasons.
Yes.
Yeah. Okay.
But a final point, even if the court were to conclude that there is no valid proxy for inability to work, I say that the absence of a proxy is not determinative of whether there's a valid status, because in McLaughlin and Jackson, no proxy existed in that case, or those cases, to determine whether couples were cohabiting, but the court still had no difficulty in finding that that was a valid status,
Okay.
and indeed that it wasn't sufficient to justify excluding non-married couples from BSP. That deals with status. I'm going to take justification at a clip, and I'm only going to address the Secretary of State's oral arguments on justification as they were set out yesterday, because it appears that a number of arguments which were raised in the Secretary of State's skeleton have been abandoned. So, taking the points that Mr. Sheldon made yesterday, first of all, suspect ground. The Secretary of State's first argument was that the High Court should have applied the lowest threshold test in terms of intensity of review because the status relied on was not a suspect ground. And Mr. Sheldon contends that the judge should not have declined to decide whether the claim's status was a suspect ground. In relation to that, my submissions are as follows. First, Mr. Justice Kerr was entitled not to decide whether the claim status was a suspect ground because by adopting the manifestly without reasonable foundation test, the High Court adopted the lowest standard of review available. And put shortly, that's sufficient to dispose of that ground of appeal. But second, and in any event, if this court were minded to make a finding that the claim status was a suspect ground, then I would submit you'd be right to do so. Because as we've seen, the starting point is that disability itself is a suspect ground. In fact, I don't think I've yet established that point, but it's established in the Supreme Court case of SC at Divider 47.
We haven't yet been taken to SC.
No, that's right. Obviously, a seminal case in this area, but I'm just going to address suspect ground, and this is dealt with in Lord Reed's judgment, starting at paragraph 99. And I'm not going to invite the court to read this because there's too many paragraphs, but the paragraphs are 99 to 113. And in this section of the judgment, what Lord Reed does is to go through all of the grounds that have now been held to be suspect grounds. He goes through them one after another, sex, race, and so on. And at paragraph 112, I submit that what he is finding there is that people with disability is also a suspect ground. So it's paragraph 112 and then paragraph 132 where he concludes that section of reasoning, and he says the case concerned in reference to JDNA against the UK, 2 complaints of discrimination, one on ground of disability, the other on gender. Those are both suspect grounds, as explained earlier.
But doesn't he go on to say that the whole area has become over schematic
Yes.
and over tick box? These are all factors to bear in mind.
Yes.
But the idea that you go up a step when you tick some box like suspect ground is not helpful.
Exactly, he does. And indeed, in this case, I submit that Mr. Justice Kerr dealt with this in the right way by just applying the lowest threshold of intensity of review, the manifestly without reasonable foundation test.
In which case, the whole suspect ground point really goes away, doesn't it?
It really
But
does.
I thought in your respondent's notice you were suggesting that he ought to have adopted a higher standard of review.
No, that he ought to have found that this was a suspect ground. What we've said in our respondent's
Oh, I
notice.
see, okay. But then where does that get you?
Well, that's our point in our skeleton, that there's nothing in this point about suspect ground because
Well,
the
that's-
judge gave the Secretary of State the benefit by applying the lowest intensity of review possible.
Okay, but a lot of this all drops away if there is no issue that manifestly without reasonable foundation is the correct approach. I quite agree with you. I had obviously misunderstood your respondent's notice.
The respondent's notice at page 72 of the core bundle is that the judgment of the Northern Irish Court of Appeal, it's 1B, relatively intensive degree of scrutiny in comparison with the scrutiny appropriate to other provisions of legislation is appropriate, taking into account that the relevant status is a suspect one. So what we say is, yes, your lordship is right, there should have been more intensive scrutiny, but it's immaterial on the facts of this case because the judge applied the lowest intensity of review possible. That deals with suspect ground. The next point that my learned friend made was that the discrimination is justified because of the importance of the contributory principle. My learned friend said the contributory principle was a central aim of the legislation and that O'Donnell and the High Court below erred in law by making their own value judgment about the relevance of the contributory principle. Our position on that is as follows. This was the central argument relied on by the Department for Communities in O'Donnell, squarely addressed by the Northern Irish Court of Appeal in that case. And we say that the Court of Appeal was entitled to reach the conclusion it did, and that there's no basis for this court to interfere with those conclusions. Now, if we can please turn back to O'Donnell, which is at divider 50. I know we've looked at this many times. There's just 3 relevant paragraphs that I would invite the court's close attention to. That's paragraphs 93, 95 and 98. You've read them before. I'm going to ask you when preparing the judgment to read them again because what I submit, it's clear from those paragraphs that the Court of Appeal fully appreciated the importance which the Department for Communities was placing on the contributory principle. And in fact, we can see a list of the aims of the legislation relied on in 95. And in my submission, apart from simplification, all of those relate to the importance of the contributory principle. And the court found that they were legitimate. But their point was, you can't just rely on the contributory principle. Of course, that's legitimate, but it doesn't explain why you have excluded this particular group.
Well, doesn't it?
No, because as the court says in the middle of 93, it's the failure to treat different classes of people differently that needs to be justified.
Yes, that's fine, but you justify doing so by saying that the contributory principle is more important than the fact that this group of people will be treated less well.
That might be an argument if they'd considered that group of people and the impact of excluding them at the time. But we have a finding of fact from both the Court of Appeal and the court below.
Well, that's not conclusive, is it? I'm really not on the point about whether they were right. I'm just a point about, you're saying they didn't, that it's a complete answer to say, so I'll start again. The Secretary of State doesn't ever explain why the contributory principle trumps the discriminatory impact. But there's only a limited amount of explanation you can do. It's an assessment. If you say, I think the contributory principle is so important that it justifies the fact that some people will not get benefit who weren't able to contribute. That's a value judgment. All you can really say is, yes, but it's a disproportionate value judgment.
Yes, which of course is what they do.
Well, they do say that somewhere else, but I don't think it's right to say that the Secretary of State never explained the importance attached, or never explained why they wanted to, as it were, put the contributory principle first. It's clear they did. The important question is, was it disproportionate to do so, which is a different stage of the argument.
Yes. As to the first, obviously the court will note that the way that it's put in O'Donnell is that the fact that they didn't consider this at the time is not conclusive, but what is conclusive, this is the middle of para 93, is that there's been no after the event attempt at justifying why such an exception could not be made. Now that's as to the first point. But as to the second point that your lordship makes, that's dealt with in paragraphs 98 to 100.
Yeah.
And I'm not going to take you through it again. What they find is the adverse impact is disproportionate.
Yeah.
And I say that they're entitled to reach those conclusions. And my lord, on this point, the other authority that I handed up this morning is the authority of TP against Secretary of State for Work and Pensions. It's a Court of Appeal decision of 2020, and it deals with the correct appellate approach to deciding whether a lower court's decision on proportionality is wrong for the purposes of the appeal test in CPR 5221. The relevant paragraphs are 121 to 122. And can I invite the court to read those two paragraphs? In short, the Court of Appeal concludes it's not its role simply to substitute its own assessment of proportionality for that of the court.
So which paragraphs did you say?
121 and 122.
Yes, and how does that apply here?
So I say the mere fact that you may disagree with the assessment made by the Northern Irish Court of Appeal in O'Donnell and might have reached a different view yourself is not the permissible approach.
Well, that must be right. But if, just suppose we thought we would have reached a different view ourselves, on the provisional view which we based on Abbott and Philbin, what we would do, which you would rather we didn't do, is say we don't read. We nevertheless will follow O'Donnell, but we don't think it reached the correct assessment on that point, and we'll either give permission to go to the Supreme Court or at least flag the point out for the Supreme Court to decide whether they want to give permission.
Yes. So in a sense, the question doesn't arise.
That's what I was suggesting, yes.
But I do submit that it's important that the court has in mind what its role is in relation to the merits.
We're not hearing an appeal from the decision in O'Donnell. We're considering the reasoning.
Well, we are considering an appeal.
You're considering an appeal from Mr. Justice Carr,
who adopted
Yes,
that.
we
Yes.
adopted the reasoning in O'Donnell, and for the reasons that we've been exploring, we're not.
Yes, but I suppose the answer to my point is that just imagine O'Donnell had never happened and all the words from O'Donnell had simply appeared in Mr. Justice Carr's judgment. You would be saying, well, you can't just allow an appeal on a proportionality issue because you might have reached a different view. That's orthodox.
Exactly. And of course, we know that Mr.
So we'd have to say, but this is very standard stuff. We'd have to say not just we disagree, but we're satisfied it's wrong. In the old days, we used to say plainly wrong, and then Lord Wilson said we couldn't say that. But it's not just one we differ from, but it is wrong.
Yes.
And we've got to, if
Your Lordship has.
we've got to make up our own minds about that.
I don't need to take that further, but I did
Okay,
want to draw the
thank
court's
you,
attention to it. So the next point relied on by my learned friend was what he called the simplicity argument or the bright line argument. And he contends that the judge was wrong to reject the contention that the Secretary of State is entitled to draw a bright line as to entitlement to BSP, or to reject their arguments on simplicity. And the short point in answer to that submission is that Mr. Justice Kerr didn't reject the bright line argument. Instead, what he found is that the line in question was manifestly not drawn in a justifiable place. That's the point I've made in my skeleton. And if it's necessary to do so, I'm just going to give the court the paragraph references to the Kerr judgment, where I say Mr. Justice Kerr took on board the arguments about the desirability of bright line rules and found that they weren't justifiable. Paragraphs 58, 68 to 69, 87, 89, and that's where the judge finds that he agrees with the Northern Irish Court of Appeal's reasoning in paragraphs 98 to 100 of O'Donnell. Now, my learned friend complained yesterday that that's not sufficient because the Court of Appeal in O'Donnell didn't address the Secretary of State's arguments on bright lines or the need for simplicity, but I say that that's incorrect. The paragraph references to O'Donnell, where the Court of Appeal did, I submit, consider the simplicity or bright line arguments, are paragraphs 95, where the Court of Appeal summarises the Secretary of State's aims for the measure, which includes simplification of the benefit system and simplification of the contribution condition, and finds them to be legitimate aims. And that, in essence, is a reference to the desirability of a bright line rule. But then at 98 to 100, they go on to say that the adverse impact of excluding this class of people is disproportionate to the likely benefits of the measure, including simplification. And in any event, Mr. Justice Kerr then goes on at paragraph 92 to refer to the Northern Irish guidance, and he says this: but if, as I consider, the Northern Irish decision is correct, it still doesn't have enough weight to sustain the justification defence. In other words, the judge has taken account of the bright line or simplicity arguments and has found they're not sufficient to justify the adverse impact. Now, I submit that both of those findings of the two courts are manifestly open to those courts and shouldn't be disturbed in this court. Now, the Secretary of State cited a number of cases relating to the desirability of bright line rules, and I agree that the cases cited by the Secretary of State in paragraph 36 of the skeleton argument are authority for the proposition that bright line rules in legislation are often desirable. But those cases also make clear that it's for the court to decide ultimately whether the line is drawn in the right place and whether the bright line that's been adopted is a proportionate way of achieving the aim of the measure. And those cases, for your record, are Animal Defenders International, Authorities Bundle tab 24, page 553, at paragraph 33, letters B to D. RJM, which is Authorities Bundle tab 25, at paragraphs 54 to 57. And Tigiri, Authorities Bundle tab 31, at paragraphs 36 to 42. And in that case, Baroness Hale held in those paragraphs that even if a bright line rule is justified in a particular context, the particular bright line rule chosen must still be rationally connected to the aim and be a proportionate way of achieving it. And so the fact that Parliament has enacted a bright line rule doesn't mean that justification arguments are out of bounds. And in fact, it's perfectly open to a court to find that the bright line has been drawn in a place which is manifestly without reasonable foundation. Now, a brief reference to the case of In re Brewster, which is the Supreme Court case decided in 2017. That's at Authorities Bundle, tab 35. And in that case, the Supreme Court makes clear that the desirability of a bright line rule is of marginal significance where no consideration was given at the time of enacting the measure to the impact of the measure or to the administrative difficulties of drawing the line in a different place. If your Lordship wishes to go there, it's tab 35 in the second volume.
Hasn't there been some further observations about Brewster, suggesting that went a bit far? Or am I imagining that?
No, my lord, it has been corrected in terms of its approach to manifesto without reasonable foundation.
Perhaps that's what I had in mind.
I'm grateful. The relevant
In what case is that, Mr.
I think it was then in DA, which I think you have in the bundle, and then everything obviously has been, because the question was on looking at the four-prong test under Bank Mellat. I think in Brewster they say you don't look at manifesto without reasonable foundation at each step of the way.
I see, so that may be a different point. Okay, but then but the DA is where we should look if we just want to check that.
I think it's DA.
Thank you.
I'm grateful. The relevant paragraphs in Brewster, just for your record, I'm not going to go there, are paragraphs 62 and 64 about the desirability of a bright line rule being only of marginal significance where no consideration has been given to impact of excluding a particular group. Now, the Secretary of State referred to a number of so-called advantages of a bright line rule and included the fact that there's no single proxy. I've dealt with that. And alleged that it's going to result in slower and more subjective decision making because of the need for individualised decisions. And my learned friend mentioned the increase in the risk of fraud. And insofar as those points have not already been addressed by Mr. Justice Carr below, we make the following short submissions. First of all, no evidence has been advanced by the Secretary of State to substantiate the assertion that giving effect to our requested exception would cause significant administrative difficulty or would increase the risk of fraud. And we say that's particularly surprising in circumstances.
Why forget fraud for the moment? Isn't that what Ms. Walker's witness statement does?
Well, in relation to this individual case, yes. I mean, we submit that Ms. Walker's made rather a meal out of looking at the records. All that has to be done in Mrs. Jwanczuk's case was to look to see whether she had continuous entitlement to incapacity type benefits and cross-check to make sure she hadn't received any benefits inconsistent with that.
Yes, but those are exercises that will have to be gone through.
Yes.
And as I understand it, that's done perfectly appropriately as an illustration of the kinds of problems that are likely to arise.
Yes,
and they will be greater for people who are older.
And of course I have to accept that this kind of individualised decision making will involve more work than your classic claimant for BSP. What we submit is the evidence of how much more work that will require is not sufficient to justify excluding this entire category of people. like Mr. Jwanczuk. Our second submission is that in any event, this is not a classic bright line situation because there's already been express exemptions made in the legislation that are going to have to require individualised decision making, particularly into whether or not someone's died of an industrial disease or injury.
Well, is that quite right? There's more than one bright line at issue, isn't there?
Well, I suppose it depends how one defines bright line, but there's no question that in the industrial injury and disease categories, it's going to have to be individualised decision
But
making.
Parliament specifically considered those cases and decided to make exceptions.
Yes.
It's drawn another bright line for everybody else.
Well, I can't take the point much further.
No,
That is my submission.
Yeah.
And thirdly, in relation to the assertion that putting in place an exception for this particular class of people will slow down decision making, first of all, we're only talking about an exception for probably a small category of people, and we've had no evidence from the Secretary of State that we're talking about a large category of people. So for most applicants for BSP, it's going to be perfectly straightforward. So we're only talking about the decision making for the class that we are seeking to accept. And we submit that it's not only manifestly unreasonable, but offensive to suggest that prioritising speed of claims processing and of claims payment is a sufficient justification for excluding this class of people from entitlement to the benefit altogether.
No, but I don't think the point is just about it'll be a lot of work for us, the department, and we've got better things to do. Might be rather offensive. It's more that it's the character of the benefit. This, of course, people's circumstances will vary enormously, but on the whole, this benefit is designed to give you a lump sum very quickly.
Yes.
And then also an entitlement to some payments
Yes.
thereafter over a period of, I think, is it 18 months?
Yes.
Certainly, so far as the lump sum is concerned, if these inquiries take weeks or months, I have no idea whether they would, you may say we haven't got enough evidence about that, the lump sum will be delayed very considerably for the people for whom it's intended.
I accept that. But our argument is that if you were to ask Mr. Jwanczuk,
Yes, okay. I
would
see.
you rather have a delay in payment or no payment at all?
Yes, I see the point.
It's pretty clear that they would say we'll take the payment even if it's delayed.
Yeah.
And it's not on, we submit, to suggest that it's more important to prioritise speed
Yep.
over excluding this category of people altogether. People in the shoes of Mr. Jwanczuk would prefer some delay than to be denied entitlement. And of course, a claimant who thought that the process was too long or too difficult wouldn't be required to claim this benefit. They're at liberty not to make a claim if that's what they're worried about. And finally, a point I've already made before, that arguments about administrative difficulties were considered and rejected in McLaughlin and Jackson. The next argument that Mr. Sheldon makes in relation to justification, and I'm going to be on time at finishing at 12:30 just to reassure the court and my learned friend. The next ground that he relies on under the justification heading is the argument about whether the Northern Irish Court of Appeal erred in applying international conventions or considering international conventions, and that Mr. Justice Kerr erred in thinking that the observations made by the Court of Appeal on O'Donnell about international conventions were obiter rather than part of the ratio. And the Secretary of State contends that claiming that the references to international conventions were obiter instead of ratio somehow affected Mr. Justice Kerr's reasoning on justification. This argument can be addressed very briefly, and it's set out for your note in paragraph 79 to 81 of our skeleton. First of all, the judge below was correct to find that the comments in O'Donnell about international agreements were obiter. The Secretary of State has ignored the use of the word confirmed in O'Donnell at paragraph 99. I'm not going to take you back to it, but it's perfectly evident in my submission that the use of that word demonstrates that the international materials did not determine the outcome in that case. What they said is, this failure is confirmed by the respondent's breach. But secondly, in any event, that argument is irrelevant because Mr. Justice Kerr himself did not have regard to the international conventions. On that point, he reached his own decision and did not follow O'Donnell. And the proof of that, if we go back to Mr. Justice Kerr's judgment at Core Bundle tab 8, is that in paragraph 97 of the judgment on the last page,
I'm so sorry, have I misunderstood something? You said he reached his own decision and didn't follow O'Donnell.
Correct on that point.
But I thought you were saying that it wasn't part of the reasoning in O'Donnell in any event.
Yes, this is a fallback argument by you.
What Mr. Justice Kerr says is any references to international conventions in O'Donnell were obiter, not part of the ratio.
He goes further and says he
And
thinks
he goes
they were wrong.
further in 97. He makes both points in 97. He says, I agree with the submission which was made by the Secretary of State that the Northern Irish Court of Appeal ought not to have placed any weight on the breaches of the two relevant international conventions. And then he goes on to explain why, in any event, he thinks that the submissions on, that the observations made by the Court of Appeal in O'Donnell were obiter rather than ratio.
Right, okay.
So that first sentence clearly shows he disagreed with the Court of Appeal on that point, and he didn't give any weight to those conventions. So the point falls away, because there can't be any error of law in Mr. Kerr's judgment, which is the subject of this appeal.
Yeah, so what in fact he said was, he didn't say, I accept that they put weight on it and they were wrong to do so. He agrees with the submission that if they put weight on it, they were wrong to do so.
Exactly.
Yeah, okay. I now follow it. I was being a bit slow, sorry.
So whether or not you take the view that the Court of Appeal fell into error, Mr. Justice Kerr didn't.
But we've got it.
Yeah.
And so for all of those reasons, I invite the court to reject the justification arguments. And then all I have to do is ground 4 remedy. And I'm going to take this very briefly. I rely on the arguments that are set out in our skeleton argument at paragraphs 58 to 68, and I'm not going to repeat them. Our position is as follows, in summary. Both the Court of Appeal in O'Donnell and the High Court approached remedy correctly. They were entitled to apply a Section 3 remedy and read into the legislation a further exception for this class of people. Both courts were aware of the case law, which requires that any Section 3 remedy must not go against the grain of the legislation. And they were right to find that by making the requested exception for those who through disability cannot work for their entire life does not fundamentally undermine the contributory principle, given that first, the contribution condition continues to apply in the legislation. Second, the level at which it is set is extremely modest. That was the phrase used by the Court of Appeal in O'Donnell, which Justice Kerr agreed with. Third, that an exception has already been made to the contribution condition, and it's an exception which has the effect, as I mentioned yesterday, that a person could qualify for BSP having either carried out no work, so they turn up on their first day of work, but they don't manage to do any because they suffer a dreadful personal injury, or they spend a de minimis number of days at work and not enough to reach the contribution condition, not enough to actually pay any national insurance contributions. And also, for the fourth point, that no consideration was given during the passage of this Act to the impact of excluding this category of people, or to the possibility of making an exception for them. And we saw that in the rather surprising absence of any equality impact assessment. And what I submit that means is that it wasn't a fundamental feature of this legislation to exclude this specific category of people. No one thought about them except as part of a group of people from whom they were relevantly different. So those are the four reasons why I say that both courts got this point right, but in any event, given that part of the ratio in O'Donnell was the remedy that it gave, and that it was possible to construe the BSP legislation in line with Section 3, I submit that if you are provisionally minded to follow O'Donnell, you must also follow the remedy that they granted in O'Donnell. My Lord, I'm just going to check behind to see if there are any other points. And those are the submissions for Mr. Jwanczuk.
Thank you, Ms. Keller.
My Lord, I will seek to make a number of points in reply and recognise the time limitation. First point to make, my Lady Justice Laing wanted to know where Annex D was. It was an annex to one of the impact assessments. Apparently it's at page 223 in the supplementary bundle. So it is actually in the supplementary bundle.
Thank you. Page 223.
Page 223, yeah.
Thank you.
Yesterday I mentioned when we were looking at the employment support allowance regulations that there may be categories of individuals there who would or could satisfy the contribution conditions. And I mentioned as possibilities that I was going to check, which were councillors and those who sat as tribunal members of the first tier tribunal. And my researchers, and I can hand up some documents which relate to that, suggest that they would fall within those who would pay the necessary amounts of national insurance. I can just hand up two sheets. One is relating to judicial fees for members, and one is the members' allowance scheme from a local authority. I mean, I just chose London Borough of Camden because it's close to here, but it's pretty similar probably around the country. And one can see from the judicial fees that you have a member who sits on the in a social entitlement chamber. In the social security and child support section, there's a reference to member with experience of disability, and they receive from 2020 £214 per day of sitting. So it's on the second page of the judicial fees document that I've handed up. That would satisfy the £190 that I referred to yesterday, and if they sat, I think 15 days a year, they would meet the gross earnings factor, the earnings factor. And in terms of members' allowance, the members' allowance for a year, so the basic allowance for a councillor in the London Borough of Camden, and I've just found the 2021-2022 rules, is £10,795, and that is the equivalent of £207 per week. So therefore, they would also.
Where do I find that?
So, my lord, if you see the document which says members' allowance,
Yeah.
if you look up the names of each of the
Oh, I see. Sorry.
Members,
Yes, of course. Okay.
the
And what's
annual amount.
what's the arithmetic? How much is a day?
I've worked it out as £207 per week.
Okay.
But my lord, that's just another reason why my suggestion is that the proxy ought not to, or the suspect class or the class should not, the status should not be defined in the way that your lordship has put forward.
But they still need to have undergone an assessment.
No.
as to the-
Well, yes, they have to undergone an assessment to
so
get
that's
ESA.
what we were taken to.
Yes, you were taken to that earlier, but I was making the point that people who are in receipt of ESA can still work.
Well, but they have to have passed that assessment
Yes.
that we were taken
I
to.
know, absolutely. But my lady, if you look at the, and today my learned friend took you to the functional tests
Yes.
that apply, and one can see from that one can get the 15 points to satisfy ESA because of a disability, and it may well be a severe disability, including not being able to mobilise oneself. That doesn't mean that one cannot work. And so but the whole point of that legislation and all the predecessor legislations, and this is the test of reasonable required to work or reasonably expected to work, is to get the benefit, which is an income replacement benefit. Parliament and governments over the years have said, if you have this disability, if you have this inability, or sorry, a limit on your ability to work, you're still going to get a benefit. We don't require you to work to get that particular benefit. But it doesn't mean you are unable to work. That's the first point. And secondly, we know that people are not unable to work who receive ESA because there's that whole list of jobs that people can do, and that's why I'm referring to councillors, that's why I'm referring to members of the first tier tribunal, and that's why it refers to the list of people who, for instance, can work up to 16 hours a week at national minimum wage. So it is not a proxy for inability, for being unable to work. It is a statutory benefit for
Well,
those.
the question ultimately is it a proxy for being unable to earn national insurance contributions?
Well, my answer is it's not, because I've given you an example here.
No, exactly. I'm sorry. That's what we're focusing on.
Yes.
I know we use the shorthand inability to work, but it's inability to satisfy the contribution requirement, which is
So it's not a complete proxy because we've got the example of the first tier tribunal member. In any event, but the point that I'm seeking to make is that one can receive that benefit and still be able to work. It doesn't mean you are unable to work.
You mean unable to pay?
No,
unable to satisfy the
you're
national
unable.
insurance
Well,
contribution.
if you satisfy the ESA conditions, and I gave the example yesterday of someone who works 16 hours a week, or they work 15 hours a week at national minimum wage. They can get ESA. They stay on ESA, and but if they worked an extra 3 hours a week, they would lose ESA, but they would pay national insurance contributions. Now, there must be individuals who are in that situation. And so I'm not saying they're defrauding, because they don't have, they're choosing.
We're getting a long way from the issues in this case, aren't we?
Well, my lord, it's not a long way if one is seeking to apply that as a proxy, which is essentially what my learned friend is asking for, and what your lordship
it's not
is
quite
putting
sure. It's not
forward.
really what she is asking for. It's what I suggested, and
Well, she's accepting the proposition.
she's accepting it as a fallback.
She's accepting it as a fallback. So as a fallback, I'm making the submission that it's not an appropriate.
It's not a perfect.
It's not an appropriate fallback.
Okay.
But it's also, my lord, important that it is not people can work even though they are in receipt of ESA, and why that's important is because it goes to the issue of administrative workability of any other scheme, and it in itself does not doesn't demonstrate inability to work. One would need to look at other factors as well. Now, of course, as in Northern Ireland, they've taken a pragmatic approach to satisfy the O'Donnell judgment. But the fact is, it's not by any means a perfect response, and it doesn't align with the test of inability. That is the point that's being made, and those were the criticisms that were made by Helen Walker in her statement. Now, if I can move on from that to make some other points, my lord. My learned friend yesterday made a general point about the impact on disabled persons who don't get the benefit if they're she made a point about the impact of not getting the benefit for the spouses of disabled persons, and she said, Mr. Jwanczuk, and took you through some of his background, and she said there is a general proposition that people in that situation will need resources, that they're less well off than others. That was her proposition. There is no evidence in the bundle to support that. That is not an assertion which this court should accept based on any material that you have in front of you. The further point, my lord, is that there are other benefits available to individuals who face financial difficulties at the time of a bereavement in terms of the other means-tested benefits that can be made available to them if they satisfy that. And that's exactly the point that Miss Walker is saying.
But those means-tested benefits are available to others as well.
They're available to everyone. They are available to everyone. But if the point is being made that there's an impact on me as an individual, the fact is there are other benefits that are available to them, including the fact that if you are a carer and were in receipt of carer's allowance, that does continue for a period of 8 weeks after the death of the person who you were caring for. My learned friend made the point yesterday, and I think repeated again today, that there are exemptions already provided for in the legislation that require some fact-finding. This is the industrial diseases, the industrial accident point. And she says, well, Parliament wasn't averse to that. Well, firstly, they were exceptions that Parliament has specifically included and therefore thought through. But they are also very different from the situation here, where one is dealing with a question of looking at a lifetime of someone's ability or inability to work. One may need to go back 50 years, whereas there you're dealing with an incident or an event which happened on one occasion. And
is there a closer analogy with the cohabiting couples, the subject of Laughlin and Jackson?
Well, so I understand the question, and I was going to come to that next.
Thank you.
The question with cohabiting couples, it's not a question. You don't need to look back over the entire work.
I appreciate that, but you still got to investigate.
One still has to investigate. But firstly, it is just looking at, are they cohabiting at the date of the death?
Yes.
So it's not a lengthy period where some people will know, some people will have some information, some people will have very little information. Secondly, the courts that have actually looked at this, and you were taken to that in McLaughlin, Lord Mance says, for instance, the position of a couple, this is paragraph 53 in McLaughlin, which is behind tab 39, you were taken to these references. The position of couples who are neither married nor civil partners is already catered for in the law, so there will presumably already be structures within the legal system to actually work out who is or who isn't cohabiting. And then...
Is that right?
Well, to the extent that there are provisions within the corpus of law around cohabiting, then there will have been tests applied to determine whether in fact they are cohabiting or not. But what we have in, for instance, Mr. Justice Holman's decision, which may be more to the point on this, in Jackson behind tab 44, he says, in many cases, however, including the cases of Jackson and Simpson, the fact of the long and settled cohabitation is likely to be easily and rapidly demonstrable. So there is already an acceptance that it won't be hard to reach that conclusion. But I think the further point to make with that is that was very much a very secondary part of the justification that was being put forward in those cases. The primary ground of justification there was to do with preserving the institution of marriage. That was the main reason why they were seeking to justify the legislation at issue, and that presumably is the reason why Baroness Hell doesn't even deal in her judgment at all with this particular issue. So when one is coming to look at the question of proportionality, one has to weigh up, well, if you don't have the main argument, which is and the substantial argument, which is institution of marriage, what are you left with? You're left with a very what they decide essentially is a slender justification. Now here we have a number of justifications which include that point, but it also includes the bright line simplicity point, and it includes the contribution principle. And my submission is that the contribution principle is a valid proposition, and it is wrong, and it's an error for the other courts to have basically downplayed it in the way that they did. My learned friend has made the point that there was not a specific consideration of this particular category other than grouped with others who didn't satisfy it. But that ought not to affect the intensity of the review that this court should be considering, or the way in which the other courts that have looked at this matter have considered it. Because this is not a case where that category was simply ignored, not noticed. It was there in the consultation documents. It was there in the submission to the minister. The fact that they didn't decide to provide for a specific exemption doesn't mean that they didn't think about it. They obviously just decided that it wasn't something that needed an exemption. It is surprising in some ways that no one picked up on it in the parliamentary debates. If one looks at parliamentary debates around these kinds of benefits, one has, particularly in the House of Lords, different members who put forward amendments on lots of different things. No member of the House of Lords, and this was shepherded through the House of Lords by Lord Freud, suggested an amendment for this category. Not because they weren't aware of it, because it was in the consultation response, but presumably, and this is what I'm asking you to infer, because no one considered it necessary to provide an exemption for it. So in those circumstances, there is no reason to downplay the intensity of review, or to increase the intensity of review, as my learned friend suggests. They were familiar to a particular point, and obviously no one chose to put forward an exemption. My learned friend today essentially says, in respect of Mr. Jwanczuk, that she said it was offensive to make the point about administrative complexity versus bright line, and he would rather have had a chance to apply for it than not to have a chance at all. But that is the reality of hard cases, as indicated in the bright line rule cases. There will be hard cases, but the question is whether or not there is any merit in the bright line, and whether in fact the bright line has been put in a place which is not manifestly without reasonable foundation. there is in fact a benefit in knowing that you aren't going to get it. It may be not in Mr. Jwanczuk's case, but in other people's cases, because they can plan better for what their financial situation will be when their partner passes away. They will know that they can't get bereavement support, and therefore will make or have to seek to make other arrangements. And as I've indicated earlier, there are alternative benefits that may be available to them that they can seek out.
So what other means tested benefits are available?
Well, so there would be job seekers allowance, for instance.
Right.
So Mr. Jwanczuk was the carer and a paid carer of
Yeah. Okay.
his wife.
got that.
He could then apply for job seekers allowance.
All right.
Then moving on to some of the points that were made today. There's a reference to dean and the language of relates to, set out by Lord Justice Ward, something that relates to statutory interpretation. I'm submitting to the court that one shouldn't read Lord Justice Ward's judgment as if it was a statute where he says relates to. And in any event, he wasn't dealing with the Human Rights Act challenge, and therefore one does not know whether or not the same language would have been used had there been a Human Rights Act challenge. Further point, the case of RSB, the Commissioner's case that you were taken to, at paragraph 15 in that judgment, one of the bases for why they were prepared to say that one should follow, or one is bound essentially to follow a Commissioner's decision from the other jurisdiction, is they said at the end of the day, the legislative fount is the same, namely Parliament in Westminster, because at that time, that is the legislative fount for that legislation. Now, when you have the devolved administration, it is not the same legislative fount. You've got the Act, the Pensions Act of 2014, and then you have the Pensions Act Northern Ireland 2015. And the final point, unless my learned junior has anything else that I need to mention, is my learned friend, in seeking to defend the judgment of O'Donnell between paragraphs 98 to 100, says, in terms of whether or not they took into account the simplicity point, says, well, look, they referred to it at paragraph 95. Well, that is correct. At 95, the Northern Ireland Court of Appeal does refer to the simplification of the benefits, but you'll struggle to find any reference to it in their analysis and in their reasoning between paragraphs 98 to 100. Had they done so, my learned friend would certainly have pointed that to you. I submit that that is in itself an error of law, because they have simply not grappled with that point insofar as that point was put to them, and it looks to me as if the matter was put to them. And also, there is one other point. My learned friend suggested yesterday that this case has the same evidence as O'Donnell. It doesn't, my lord, in the sense that the Helen Walker witness statement is different for this case than was the Helen Walker statement that was put in O'Donnell, because that related to a different case.
Well, obviously, but
but her witness statement deals specifically with what she says is the unworkability or the difficulties.
we don't know whether UNA.
No, in terms of the Northern Ireland guidance, which relates to
of course,
how
yes.
to give effect to O'Donnell. So that's
That's obvious.
that
The
material
only one
is
suggesting that by definition wasn't before
so,
then.
so my lord, so that is different evidence. But and secondly, in her witness evidence, she explains why the an exemption ought not to be provided for this particular category, however one defines the category. And to the extent that O'Donnell is correct where it says no after the event justification has been put forward, that is simply not the case in the present appeal and the present case before the High Court. My lord, those are my submissions, unless there's anything else you wish to hear from me on.
Yes, Melanie had a question.
May I just ask one question, Mr. Sheldon? Somewhere in the bundle there are some regulations about contribution credits. Is that an exhaustive statement of the circumstances in which people who don't meet the contribution condition will nevertheless be treated as having met it?
For the purposes of other benefits.
Yes.
Perhaps a pension, isn't it?
Well, it's essentially for state pensions.
It's essentially for state pension.
And it may be that there are some other benefits for which it qualifies, but I don't.
Right.
I don't know
Because
that.
what I was interested in knowing is whether there are other circumstances apart from state pension in which somebody who doesn't meet a relevant contribution condition is nevertheless treated as having.
Well, I'll
met
have to
it.
take instructions.
All right,
and
that would be
and
helpful.
answer that.
I mean, they may not be able to provide an answer straight away. They don't
My
know.
lady, the answer is they don't know, but I can seek to find out that answer, and we can send you a note.
You send us an email this afternoon.
An email this afternoon
first
if
thing,
that
or,
is.
or tomorrow if it takes that long.
Will do.
Thank you. Well, thank you very much. We will be reserving our judgments. Draft judgments will be circulated in the usual way to those council and others of whom we have been provided with details before this hearing. I assume that schedule has been done. I haven't actually seen it. Any other circulation by the recipients can only be for the very limited purposes identified in the Council General for Wales, a case of which I'm sure you're familiar. We will welcome observations not only on, indeed not primarily on typographical and other minor factual errors, but on the terms of a order giving effect to the judgment and any relevant submissions that might, in this particular case, be need for a rather more full examination of the question of permission to appeal to the Supreme Court than would otherwise arise.
My lord, may I ask the indulgence of the court that if you are, if you can give us a little bit more time than the normal time that is provided between the sending around the draft judgment and then the hand down, because of that particular reason, because one ordinarily gets just a couple of days, and if there is going to be an application for permission on either side, there might need to be a little bit more time given to considering that.
I think there might almost be less time, because we will already,
Well,
in the circumstances where it's likely to matter, we will have expressed a provisional view, I suspect.
My lord, if you've done that, that's one thing. But if you haven't,
We will bear in, we will take a sensible view.
Yes.
And there's always the possibility, which normally I strongly discourage, that if at the time of hand down you're still not in a position to decide whether you want to make an application for permission, to ask for a bit more time. As I say, normally we don't approve of that because it shouldn't take long. But in this particular case, if we haven't given you enough time, you can always say so. But we'll bear the whole question in mind.
My lord, I'm
On the whole, we do not like judgments existing in known only to the parties for more than a very few days.
My lord, I do appreciate that. Thank you very much.
Thank you. Thank you very much. Yes.
Court rise.
I should have said, as is the case, we're very grateful for all the hard work that's gone in, not only from council, from who we heard, but from everyone, the teams behind them.
Court rise.